Imagine you go to work one day and your employer suddenly tells you that you are dismissed and should not come back from tomorrow. No warning, no written notice, no proper reason. The question is, can an employer dismiss you like this in the UK? In many situations, the answer is no. But many employees do not know their legal rights, and they accept dismissal without understanding whether it was legal or illegal. In this video, we will explain unfair dismissal in the UK and what you should do if this happens to you. Watch till the end because this information can protect your job, your income, and your legal rights. Welcome to BritLaws, where we explain UK laws, legal rights, and legal awareness in simple and practical language so you can understand your rights and protect yourself legally. Today's topic is unfair dismissal in the UK. If you are working in the UK, this is one of the most important employment law topics you should understand. In the UK, an employer cannot dismiss an employee unfairly if the employee has completed the qualifying period of service, usually 2 years. A dismissal is generally considered fair only if the employer has a valid reason, followed proper procedure, given warnings where necessary, conducted a disciplinary process, and given notice period or pay in lieu. Valid reasons for dismissal may include misconduct, poor performance, redundancy, legal reasons, capability issues. If proper procedure is not followed, the dismissal may be considered unfair dismissal. As an employee in the UK, you have several rights related to dismissal. Your important rights include right to written reason for dismissal, in many cases, to notice period or payment in lieu, to disciplinary hearing before dismissal, in many cases, to appeal against dismissal, to protection from unfair dismissal after qualifying service, right not to be dismissed due to discrimination, right not to be dismissed for asserting legal rights. Dismissal may be automatically unfair if it is related to pregnancy, whistleblowing, trade union membership, asking for minimum wage, reporting illegal activity, discrimination. Let's take a practical example. Suppose an employee works for a company for 3 years and suddenly the employer tells him not to come to work anymore without any warning or disciplinary meeting. In this situation, the employee should ask for written reason for dismissal, check employment contract and company policy, ask whether proper disciplinary procedure was followed, keep records of all communication, do not immediately sign any settlement or resignation letter without advice. This situation may potentially be unfair dismissal depending on circumstances. Now, an important question. What if you believe you were unfairly dismissed? In that situation, do not panic, do not react emotionally, request written reason for dismissal, collect all documents, contract, payslips, emails, warnings, and letters, write down timeline of events, file an internal appeal if available, and seek legal advice. Many cases become strong because employees keep proper records and documents. If the issue is not resolved internally, you can take legal action in the UK. General steps are 1. Collect evidence and employment documents, 2. Submit internal appeal or grievance, 3. Contact ACAS for early conciliation, mandatory before tribunal, 4. Attempt settlement through conciliation, 5. If not resolved, file a claim in the Employment Tribunal. Possible claims include unfair dismissal, wrongful dismissal, notice pay, unpaid wages, discrimination. Remember, there are strict time limits for employment tribunal claims, usually around 3 months from dismissal. So today, we learned employers cannot dismiss employees unfairly. Proper procedure must be followed before dismissal. Employees have rights to notice, procedure, and appeal. Some dismissals are automatically unfair. If unfair dismissal occurs, legal action can be taken. The Employment Tribunal can hear unfair dismissal claims. Understanding unfair dismissal law is very important for anyone working in the UK. If you are ever dismissed from a job in the UK, do not panic and do not immediately accept the situation without understanding your legal rights. Stay calm, collect documents, request written reasons, seek legal advice, and follow the legal process. In the UK, the law protects employees who understand and assert their legal rights properly. If you want to learn more about UK laws, employee rights, tenant rights, police powers, and immigration laws, follow and subscribe BritLaws. Join us in the next video as we discuss about UK visa refusal. See you in the next video.